what she would tell me is I have owies. And she started directing attention to her private area. And the night that I finally took her to get examined by a nurse, she had actually had Desitin placed inside her vagina. And during the examination, my daughter had injuries to her anal area and her vaginal area. And this was going on during visitation with the parental influence. I had petitioned a motion to modify, outlining all the allegations of abuse, medical neglect for her autism, physical neglect of her needs, emotional and mental distress, and sexual abuse. The parental influence actually stated that because he had taken her on a walk with a dog and my daughter had fallen and her heel went up inside her vagina, and that's how she was injured. The judge heard all this, put in the papers that she agreed that the allegations were proven to be true, so she gave me sole managing conservatorship, but gave him extended unsupervised visitation. I'm being told there's nothing I can do about it, that I have to comply with this court order.
It would be like if your house is on fire and you say we can't talk about it or allege that it's on fire. Or if somebody's being beat up in the parking lot and we say, well, we're just alleging that it's being done. No, it's being done.
And during formulating this extended visitation plan, she says, well, if sexual abuse is really going on, then you need to get to the bottom of this. But let's go ahead and continue on with the rest of our visitation plan. She did nothing. She didn't report it to the judge, nothing. It was just kind of like a blip in her schedule. Like, let's just continue on with scheduling this visitation. Continues to be re-victimized, continue to see the same injuries. And the final straw for me was my daughter came home from a visitation. Baby M had a huge bite mark on her leg.
She was bit by a dog. She was bit by another child, a mouth of an adult.
Mouth of an adult, a human. When she first sustained sexual abuse injuries, she was 2. By the time this bite had taken place, she was 4. So during this time, when they're supposed to be investigating crimes against baby M, I'm being told initially when she's 2, well, she's too little, she can't communicate to us what happened, so you're just going to have to wait and gather more evidence and wait until she can say something. So then she gets old enough in their eyes where what she says holds some truth, and they tell me that I'm coaching her.
You were coaching her while she had redness and soreness and bites, and you coached that too, I assume.
I asked baby M what happened, and she told me that she had been hit. That was the word that she was using. The counselor asked her, said, who did this to you? She asked, how did this happen? What happened? And my daughter told the counselor that daddy had hit her. I went forward, tried to get another protective order, was denied. The judge saw the photos of the bite mark on baby M's leg. She heard testimony and she denied that she believed anything had happened to my daughter, that it was not abuse, that the parental influence had done nothing wrong. And then she ordered me to immediately hand my daughter over for unsupervised access that day at noon. Upon hearing that I was going to have to hand baby M back over to the very person that she identified many times. This was not the first time she identified that he was harming her. The judge would not put anything in place to protect baby M. I couldn't get help from the police. I couldn't get help from the DA's office. I was forced in a position where I withheld visitation. I broke the court order. I was now in contempt, and I fled with my daughter during the time that I was in hiding, that I was protecting her. A default judgment order was put in place giving the parental influence sole custody of baby M. Default order was put in place. Parental influence then immediately filed kidnapping charges against me. And I was hunted down with my daughter. And in March of 2016, I was arrested, booked in the Boone County Jail. I spent a week in that jail, and I spent 4 days in transport. back to El Paso County, took my daughter. I didn't get a chance to say goodbye to her. I told her I'd be right back. That was the last thing I've said to her.
You know, why would any mother want to protect their child from sex abuse? I mean, that's just a barbaric thing that you could possibly even dream of, trying to protect your child. Did anybody think for a minute that this was harmful to her, to strip her away from her mother who loves her?
I still don't understand why I was charged with aggravated kidnapping.
In the state of Texas, when it's aggravated kidnapping, it's very specific, and it states that it's where you kidnap the person where the victim suffers seriously bodily injury harm, and you're holding a person for ransom or reward, which is nothing Kristen and I were doing to our daughters.
In March of 2017, that the charges were dropped. That's no longer, hanging over my head, but I still don't have baby M. I haven't seen her for almost 2 years. Phone calls not received. The other parental influence actually disconnected the only phone number I had to reach him through. So I couldn't even try to call through the phone for about a year. Recently, I have filed a motion to modify.
Federally, when you're a domestic violence victim and someone's being abused, you're legally allowed to go to any state you want. Nobody honors that anymore. Okay? Nobody honors that, and it's despicable. Okay? Because criminals have more rights, not legitimately and not legally, but they're given more rights illegally and unlawfully. Okay? Pseudo rights over victims. And you guys didn't have a federal confidential address, because under that program, you're even triply protected, and they violate that as well.
No protective measures were ever put in place for baby M or me, ever. I reached out to every channel I possibly could for help, and it fell flat. Nothing happened. So I was left to make the only decision I knew to make, and that was to leave and seek help elsewhere. And not a lot of people understand the nature of what a domestic violence victim is up against when they go into family court. You are losing before an order is even put into place.
This party, according to the Facebook post, and it's a public post, took place in December of 2015. And that's when my daughter was in hiding with with my granddaughter to keep her safe.
What was he doing at that party? Who was he with?
At the Christmas party, and he's there with the judge.
I found that amazing that a judge would be in such a party picture. But I mean, she should be celebrating and having a good time while she's abusing children and families. I mean, why not?
So it was a private, intimate party at a home, and Yahara Lisa Gutierrez is there, the judge over my daughter's case, and another family court judge, Laura Strothman, was there as well. And Laura Strothman was my daughter's first attorney way back when this first started, and my daughter fired her for unprofessional behavior and for not vigorously defending her as she should have, and then she hired a new attorney. So both of those judges, both family court judges at that party where he was with them.
Somebody's next to him. There's a young lady with dark hair.
That picture is the picture of him with the judge's daughter. His body language in that picture is very, very interesting to me, because it looks like a message to me, like, aha, look who I know. I know the judge's daughter. Mm-hmm. And that picture was posted a few months after my daughter was arrested.
I must be so foolish. I always thought that was a conflict of interest, but it probably isn't anymore, because, we don't follow the real laws of the land anymore. That's nice.
So he's at a party with the judge who is overseeing my daughter's case, and then he works with the criminal judge's daughter, and he made sure to put that out there publicly. A complaint has been filed against the judge for that inappropriate behavior, for being at the party with my granddaughter's father. Who knows what was discussed at that party? Who knows? It's inappropriate. It's the appearance of impropriety. That other judge, Laura Strothman, she was my daughter's attorney in the very beginning, and she became a judge later. So, now she's a family court judge. And she's also on my granddaughter's father's Facebook friends list as well. A lot of concerning relationships. My daughter tried to get help from every legal appropriate channel over and over again, and no help. No help.
This same judge gave my ex-brother-in-law, who is a paternal uncle with no legal standing for custody rights. He was at the time an attorney with a suspended law license. He was practicing with a suspended law license. And not to mention, he has also an arrest record for domestic family violence. This judge basically gave him custody of my daughter, and she gave me supervised visitation. And the reason she told my attorney that she did this was because I violated also her custody order, her visitation order. Immediately filed an objection to the order. Because an objection was filed to the order, same story as Kristen, I have not seen my daughter for almost 2 years, and try to get my case out of this judge's hands and docket to another jurisdiction and a state where my ex's family didn't have any connections. So I'm currently in Washington State, getting ready to also file modification orders to try to regain custody of my daughter as the only living parent.
Now arrives the hour of action.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness.
That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it.
For depriving us in many cases of the benefits of trial by jury.
To subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws.
All experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed.
But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security.
We mutually pledge to each other our lives, our fortunes, and our sacred honor. And we're going to take our country back from these people.
What's up, everybody? Welcome to Judiciary Saturday night. We turn this down. So I'm still having some serious mic problems here. See what happens if I turn this down and turn something else back up. I'm gonna have to switch microphones or something. There's so much static with this thing. I looked into it, and in fact, a lot of people have the same problem. So it was just luck of the draw. It's bad luck. Seems to happen a lot to me. But anyways, please share this show. There's lots of amazing information from the Marches Live, Punished for Protecting, and Kirk's Law Corner. So what I can do when I'm on Facebook probation is share individually. Get out of that. And so that's what I did. Who's watching so far? Oh yeah, I know Mary's been feeling pretty bad lately. Yeah, you don't need to come on, Mary. The Honorable Mary Elizabeth Bullock. This is a show that reiterates what's happened through the week. You know, we focus on points made. 7 of them. 7. Ow. Kind of hurt. I still have wicked tendonitis after the surgery in my left hand. So anyways, if you don't know how to play the game, we need at least 2 participants, but we can play with multiple participants. That's even funner, because if we get 3 or 4 people, the way we play, or the way we would play, if we had that And there's one. Hold on, let's see who this is. 3391, welcome to Judiciary! Saturday night, Judiciary. Who are we speaking with, please? Hello, 3391. Welcome to Wheel of Judiciary Live. There's a little bit of a delay. Sometimes it takes a second for people to figure it out. So anyways, oh, she's got a real bad delay. Sounds like 10 seconds. So the way we play with multiple people is, if you know the correct answer, you just yell out your name. So I'd yell out, Ted Bob! And then I give the answer. Yeah, I can hear the delayed broadcast in the background.
Can you hear me?
Yeah, I can hear you.
Can you hear me?
Yes, this must be Ante. No?
Am I on?
Yes, you are. You are live. Who is this?
Am I on yet?
Yes, you are. Yep, you're on live on.
Hello?
Yes, I can hear. Judiciary, I believe that's Ante Pat. I don't even know how to pronounce your last name. Patrick? I have it written down somewhere.
Can you hear me?
Oh yeah, I can hear you just fine.
Yeah.
Yep. You are a little quiet, but I can hear you.
Can you hear me now?
Oh yeah.
No, it's like super delayed. I couldn't delay, but yeah.
You've got like a 10-second delay on the show. So just I guess just pay attention to the phone call and turn off the show for now. You've got quite a delay. Where are you located anyways? Just so I know why you're getting such a delay.
I have to call back.
All right, call back. There goes our one participant. So, please call. Who do we got? Brian Van Aken. Brian, you've been commenting a lot lately. Ante Perick. That's how you. Ante Perick. I believe that was Ante. Brian Van Aken, you've been commenting a lot. Why don't you call in? You know this stuff. Holly, of course, please call in. Nate. Jesse Stormferrio, if you want to call in and play this. You're not really part of family law reform, but alright, that is Ante again. Ante! Can you hear me? You are on. Judiciary! Live Saturday night. Let's give him 10 seconds. I can hear you loud and clear. Alright, while we're waiting for... Alright, another participant.
Yeah, am I on?
Yes, you are. You are on. Check, check, check. Maybe it's my mic. Alright, so... Number 2072, welcome to... Judiciary Saturday night. Who are we speaking with, please? 2072.
Hello?
Hello.
Yes, I can hear you now.
All right, good. We've got Ante and 2072. Who are we speaking with?
Are you there?
Yes, I'm here.
All right.
Oh, okay.
Yeah.
So who's this?
My name is Neely. I don't know if we're on here or not.
All right. Can you guys hear me or no?
What is your first name?
Ante.
Ante.
Ante. My name is Neely.
Yeah.
Where are you from?
Neely.
Cleveland, Ohio.
Cleveland, Ohio. Well, I'm in
Everybody
Washington
knows me
State.
as the Spartan Viking General.
Hello, 1694. You are on the mark.
Everybody
on
knows
the
me
wheel
as the
Judiciary.
Spartan Viking General.
Something is going on here. They can't hear me for some reason.
Well, I'm gonna tell. I tried to call in one time before to get on the show, and I don't know. Couldn't get in, but
Zoom.
I'm trying it again. So.
What the hell is going on with this
That's why I
program?
was thinking you worked with the show when you were fixing the
We'll
problem.
just let Ante and Neely do the show. How's that sound?
Hello.
You guys can't hear me at all, can you?
Hi. I'm
No, I don't hear Ted at all.
Murphy's Law.
They don't hear Ted either.
Yep, something's wrong. All right, so.
Hello.
Yeah.
Hello.
Hi, I'm Gloria. My name is Gloria. I called in to the Zoom line.
Yeah, Gloria.
Yeah.
My name's Ante.
All right, can you guys hear me?
Huh?
Can you guys hear me? All right, let's. Flock. What the hell is going on with this thing? All right. We're good. So if everybody could please call back. Oh, man. Let's put on the time music. So I don't know what was going on. 3 participants, nobody could hear me. Neely, please call back in. Ante, call back in. And third participant, who I never got her name, call back in. That's never happened before. All right, there's Ante back. Ante, can you hear me now? Can you hear me? Can you hear me?
There is like a good 20, 30-second delay.
What is going on with this
calling
program?
back.
You still can't hear me, can you?
Dum, 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 dum.
I don't.
Putting on the music.
This freaking
It's disco time. Let's go.
I am so sick of this mic. Alright, let me try something real quick. Bear with me. Recording devices. Microphone. Set the phone. Can you hear me?
I can hear you now. Can you hear me?
Okay. Can you hear me, Ante?
Yeah, I can hear you.
What the hell is going on with this thing? Alright, can you still hear me?
I don't know. There's a good 30, 40-second delay, bro. I'll tell you like that. Between what you say on the show and when I talk across my phone.
Can you still hear me now?
Yeah, I can still hear you.
Alright, cool. I don't know what the hell's going on. Yeah, Facebook. I'm still on Facebook probation because of that group of. But so that I can't. They're just right now as far as my system goes. It says I'm not streaming on Facebook, but I am. All right, Neely.
Well, Adam's watching you on his notepad, and I'm on the phone with you.
Cool. 2072.
How you said? Listen, here's what Adam's watching.
Yeah.
So that's what they're playing on the show right now on the live feed.
It's an extra long delay. Usually it's about 5 seconds, but I'm broadcasting on my profile, not the Marches page, for this show, just for the sake of being able to share it more. But I can't tag people in the show unless it's in the title. All right, 4765. Hello, 4765. You are on. Judiciary. Friday night. Who are we speaking with?
Can you hear me, Ted?
Yes, I can. Can you hear me?
Okay, yes, I can hear you.
can hear it, too.
I don't know what was going on, but
I don't know either. Is this Neely?
yes, it's Neely.
Right. And we have somebody on the line as well, 2072. Who is that? 2072.
Nate. It is
Nate. It's who?
Nate.
Christopher.
Christopher, thank you for calling in. So,
From Maryland.
all right, everybody turn down your phones or your devices in the background so we don't get feedback, and we can play with all three of you. Do you know how to play with so the
Okay, I can hear Neely, and I heard Chris. Can you guys hear me?
Yes.
Yes.
Everybody can hear each other, I think, now. I think we're good.
Now who's on? Who's on the show?
We have Neely, Ante, and Christopher, I believe. And so we're going to...
Neely.
What?
Neely Blanchard. Neely Blanchard.
Neely Blanchard. That's you, correct?
Yeah. Yes.
All right. So this is how we play with 3 or more people. I'm going to play the video clip. I'll give you the multiple choice answers, or I'll ask you the question, the written question, then give you the answers. The first one to yell out their name gets to go. If you are correct, fantastic, we go on to the next question. If you are wrong, the other 2 participants have to yell out their name and then try and get the correct answer. So this is actually the first time I've played this way, and I'm really excited to see if it works or if it's a complete disaster. You guys into it?
Sounds good.
All right, so Ante, if you wanted to answer a question, you'd yell out, Ante! And then Neely, if you want to answer a question, you yell out, Neely! And Christopher, you know what you'd yell out?
Yeah.
All right, what would you yell?
Chris is going to go, it's Big Papa.
Big Papa. Okay, I'll take that. Just as long as I know who you are. And I better get a pen and paper to make sure I keep this all straight, because I don't have Microsoft Word open at the moment.
Hey, while you're doing all that, I just want to make a little statement. Sure. I love when you frustrate opposing counsel with the truth so bad that they hit you with paperwork in front of the judge in court during proceedings, and that they don't do nothing but arrest you for being hit afterwards.
Hit? You mean not physically hit?
That really happened to me on November 20th, 2017.
You were physically hit or hit with paperwork?
She grabbed the paperwork that I filed in the court, and I was serving her in accordance with the local rules. She grabbed that paperwork, hit me 3 times with it, and threw it in my face in the court during on-record proceedings.
The opposing counsel.
The opposing counsel.
And nothing happened.
And then she was like, "You can't serve me. You're not an officer of the court." And I said, "What are you talking about? I've been serving you every single filing by personal service. Don't tell me I can't serve you now." And then she was over like, "I'm not taking a federal lawsuit." I was like, "I'm not even here for that, man. I just put it on the record."
Yeah, I wish you could. You need to start carrying around a pen cam so you can get this stuff on camera.
You know what? There's ways to find out things like that. But I'm just first and foremost going to put together my affidavit. The one witness that was there that I know heard. You know, they didn't see, but they heard me yelling about it.
Mm-hmm.
And you know, the fact that it was on the record, and if they alter the record, that's easily found out by some IT guys. Easy.
Okay. I want to see this stuff.
So, you know,
or hear it.
Yeah, well, you know, it's just one of those things. It's going to happen. That's why I had to put it out there. So, you know, everybody pray for me and my children. You know, as I pray for you and yours. And understand that this beast realizes the Spartan general has arrived, and it is pissed that I came. Because I'm about to hand it to death.
Well, hey,
so it's facing the right man at the right time. Believe that.
Well, you've got a lot of good help. I know you're in constant communication with Mr. Hallett, and he is a wealth of knowledge, and Kirk Pendergrass, and that group. If none of you are aware, Chris Hallett's group, Amber and Steven, is where hopefully it's okay to say this publicly, but that's where more of the heavy hitters in law discussions are. And if you want any real solid information about what we're up against, that's where I go, Ante goes, Kirk goes, Chris, of course, goes, and other people. It's a pretty relatively small group.
We the people share documents that we have found in our own research that are applicable to our own cases, and we share them with others because we know many times these issues exist in such atmospheres.
Yeah, there's
so with that being said, if it applies to you, that's on you.
Right. Some of it applies, some of it doesn't. Some of us are Title 4D, some of us are Title 4E, and someone for a lot are both. And I don't know if you guys caught that opening clip that I edited of Francesca's show, Punished for Protecting, but the last guest who was talking there, this lady, during the divorce, her ex-husband dies, and the judge gave her daughter to the ex-brother-in-law, the unpaternal, not a paternal parent. It's the craziest thing, and I'm actually hoping to have her on the show in a couple of weeks. But anyways, are you guys ready to play?
Yeah, we are ready.
Yeah, let's spin some wheels. I just wanted to put that out there to protect me, so, now there's others. Because quite honestly, my case is a heavy case. As we, those who know about it know it's a heavy case. So it's one of those things where, now they've gone to violence. So I'm going public, and, I'm going to proceed in the lawful direction I'm supposed to go.
Yeah, if it's not assault, it's at least breach of peace. I mean, that's probably what it would get pleaded down to, I'm sure, outside of court. Maybe give you a little bit of a settlement and give her breach of peace a misdemeanor. That would be nice. All right, here is the first question.
Yes. I want to say something to you real quick that's really funny.
Okay.
The attorney, when I was fighting my case, I was fighting them so hard that the attorney had to hire her own attorney to come to my case, to come to my court case during my trial, and I was representing myself. And I said, I can't believe that you have to actually hire an attorney because you're that scared of me. This is when I didn't even really know what I know now. So, I mean, they're going to really be scared of me now. So,
wow, Neely.
It might even be wise to move the court to go to a public proceeding with cameras in the court at all times.
Yeah.
Because I think by me stating something like, hey, the only way I feel safe now is if we have live proceedings.
When I used to go in the courthouse, they thought they checked me. They patted me down every time I walked in the courthouse because they were so afraid that I had some kind of recording device on me because they were so scared that I would record them.
Right. Well, let me remind everybody that is it are you more scared of losing your children or losing custody of your children, or maybe going to jail for bringing in a recording device? You know what? Bring in 20.
I'm afraid that these people are trying to permanently imprison me or take my life, and I'm afraid that the reason that they're doing it is because they know I'm the avid protector of my children. I firmly have firm belief that these jurisdictions which try to claim they have standing over top of me, I have absolute affirmative, in their own writing, firm belief to have that these people are trying to take my life.
Wow.
And I fear for my life and the life of my children, especially since I know the opponent, the children's mother, used to work for them for 10 years as the boss of Children's Services when the judge was a prosecutor for Children's Services back in them days.
Right.
So I have reason to fear. And you know what? I didn't care so much about, even though it was atrocious and I suffered greatly, but I took it on the chin for the most part. When they just attacked me, when they attacked my children, they brought a Viking to war. I didn't bring this. They brought it.
Good.
Yep.
The minute they attacked my children, from that moment on, I declared war on them.
And you'll see that a lot, man or woman. You'll see whoever has connections with the court is usually the one who's going to win. And so since his ex-wife has connections with the court, he's up against it. And there's a lot of women in the same seat. This has happened to so many people because just like in the clip in the beginning, You saw a picture of Kristen's ex-husband with the judge, with another judge that is in her case, with her former lawyer, and the ex-husband in a bar with the judge's daughter. If that isn't a conflict of interest.
Look, I have a picture.
My name is Renee Johnson. I live in
another judge and another attorney. Whenever the ex's attorney and this other attorney go in this court, they dominate whatever way they want. And when they have to oppose each other, they give the act that, that we're going to be kind to each other, and this is what it's going to be. Okay. Bottom line is, I could prove beyond a shadow of a doubt that opposing counsel did not sign these motions she put into the court. She even gave testimony to that fact.
Wow.
Yep. And would not identify which one she signed, which one she would not. Would not give me the identity of the person who signed her signature. And now she's trying to claim that this other person's work, because we all know if we ever typed up a court motion, the first thing we do, one of the first things we do after we're done printing it, is sign the son of a bitch. Even if you copy and paste, you sign it. Everybody knows that because that's your work.
Right. And
so this woman didn't do that. So a person who doesn't even have standing in the case has brought forth actions accusing me of abuse, of which I was forced unwillingly under duress to answer to for no cause.
I'll show you in this.
And the person bringing the prosecution didn't even have standing.
Wow. I will show you.
So, it's one of those things. I'm sitting back and I'm saying, you know what? These are lies. They've been nothing but lies. 14 jury trials. Now, a new one. 37 false charges. Really?
Yeah.
So, they arrested me in court. They arrested me live in court because I had papers thrown at me, and they came up with the bullshit warrant that they said they had 4 days ago.
Oh, my God.
Well, I got some news for them. They're in trouble, and they don't even know it.
So this
and I have evidence to prove that that's a lie.
Wow. Wow, man.
Let's arrest them. Let's put them in jail. These people are the ones that need to be in jail. That is exactly what I'm asking the jury to do. I am asking the jury to indict, criminally indict bad actors.
Are you going to be joining Chris and Kirk on Kirk's Law Corner Monday? Are you going to be talking about this a little bit more, possibly?
I tried to get on last week's show, but my phone battery died because my battery sucks. Okay. But it kept on dying, and I couldn't get on because I wanted to say it. It was on November 20th. I wanted to get it out there right away on the record. That I have physically been attacked in this courtroom, and they did nothing but arrest me on a bullshit charge they came up with.
They don't like me in the courtroom. They try to take me. They're like, Neely, we don't want you in our courthouse because you know too much. That's what I'll be telling everybody.
Well, hopefully.
I could understand frustration. Listen, I could get it. It's okay if a lawyer yells at me. We could have a yelling match within the courtroom.
You just can't yell at them.
That's what you're there for.
You have to rise above them.
Well, let's get right into the show and talk more about this afterwards. I don't want to cut you off. I want to hear more about this, Ante and Neely. I want to talk to you more as well. But for the people listening, the 23 of them, let's get rocking and rolling here. So, you remember how to play, right? Call out your name if you know the answer, even if you get it before I ask the question. So, here we go. This is for all of you. Question number 1. And this is kind of a long... All right, here we go.
My name is Renee Johnson. I live in Tennessee, but unfortunately my daughter and grandson both are in Wichita, Kansas. Well, she has a problem finding a job out there because she has no one to help her child care. She can't afford child care. So she's having to literally live off food stamps. And he dropped the child off his insurance because he didn't want to pay for the child. And now he takes the child to doctors that are not in network, and they send her the bill because she's a primary caregiver. She actually has a house here, and then I'm here to help her. I'm a registered nurse. She was planning on going to school here and everything, and all that's been ripped up. I mean, the child was actually in school in Tennessee before legal aid forced her to come back. But the judge said that she has to stay in Kansas where she has no family, no support, and now no money. Her husband has been beating both her and the child.
I know.
He
I think
threatened
we
to
got
kill
cut
her,
off
burn her body,
on
and
the
dispose of her remains.
on the volume.
At a pig
You know
farm.
what? Let's go
Well,
ahead
is there
and call
any way to
back.
get her out of the state of Kansas, even though the divorce is just finalized for a little over a year?
I don't know.
So they
I'm
all
not
right.
watching the show
So
right now.
this is the
Oh, okay.
you guys couldn't hear that video question.
No.
No.
You're kidding me. What
No.
is going on? With
No.
this? Something is really screwed up. I'm gonna have to. All right. So here's the questions.
Just take a breath. It'll be fine. We'll get it figured out.
I'm fine. It's just a real pain in the ass. I'm wondering why you can't hear it. Something seriously must have gone wrong.
And I cannot. Also, I could see Kurt just a second
My
ago.
name is
but now I
Renee
can't.
Johnson. I live in Tennessee, but unfortunately my daughter and grandson both are in Wichita,
here we
Kansas.
are. I see the
well,
pic-
she
I
has
hear
a
you.
problem finding a job out there because
That's insane.
I hear you. I hear her. I don't hear Chris.
I'm here.
You know, big pop. Oh, there
All
you
right.
are.
Well, this is the question. Let me think about this while we get started. If you are looking to relocate to another state with your children and there has been no proven abuse, what is the criteria for you to legally be able to do so? A, the quality and continuity of the child's education. B, the stability of the home environment offered. C, the interactions and relationship of the child with its parents. D, all of the above.
All of the above.
I heard
All of
Chris.
the above.
I heard Chris first. That's one for Chris.
D.
Okay.
Hold on, let me go over here. So can you guys hear this right now?
Mm-hmm.
You can hear that, but you couldn't hear the other stuff. Okay. Chris, 1.
Yeah.
All right, so just bear with me. If it goes silent, that means the video question is going on at the end of it, since for whatever reason you guys can't hear it, and there was an update. Oh my God, there was an update. I'm gonna have to figure out what that update did. Freaking update. So just bear with me through the silence, and then I'll ask you guys the questions afterwards. That might even make it more interesting for the now 27 viewers at home. So,
Well, please keep up the question on the screen because the last time it went off, and I didn't want to read it. I want to be able to read it and answer it.
Well, the video question goes up first, and then after the video stops, then the question pops up. So let's go into the answer, and I won't go through the whole description, but I'll show everyone. So they resided there during the divorce. That's where the jurisdiction for the divorce is. Just hold tight.
yes.
Understanding what due process law actually entails is any decision made by a judge, a magistrate, through due process of law goes all the way to the Supreme Court of your state, and then from the district judge to the appellate court, and then from the appellate court to the Supreme Court for the state. All of that is part of due process of law.
So so this is, under the best interests of the child doctrine, and I wanted to go through 1 through 14 of this list. But, it talks about the parents' ability to agree. They probably aren't agreeing in this case. The parents' willingness to accept custody, or a history of unwillingness. If abuse is proven, then she can go. If not, then this would not apply. 3, interactions and relationship with the child. The father obviously is spending time with the child in this case. Any history of domestic violence. There is, but it wasn't proven in family court, obviously, so it has to go to a higher court. 5, the safety of the child and the safety of either parent. Higher court, the preference of the child, if they're old enough, doesn't apply here. The needs of the child, this is broad. The father does take the daughter to the doctor, but doesn't take her to the correct doctor, takes her to unauthorized ones, and then dumps the bill on the mother. So I don't think the court would look kindly on that. 8, the stability of the mom's home environment offered. The mother owns the home back in Tennessee, but not in Kansas. The quality and continuity of the child's education, they'd be going back to the school district. And
listen, there's a lot of variable factors into that. I'm just going to cut it like this. We got a bunch of variables. Number one, the age of the children. In Ohio, they go by what's called the compulsory school age. That's first grade. So if your kid's in preschool or kindergarten, it really don't count.
Right.
But pretty much first grade is the thing where they start measuring that at.
Yep.
They're always going to sit there and give it the view of, because the one thing you won't be able to prove in court is that moving causes stress.
Right. Right.
You know, and that's something that you have to say in court. It will be a stressor on the kid, you know, to permit this move out of state.
Right.
And it would also, you know, terminate the father's parenting ability.
Well, it does go into the parents' employment responsibilities. Right now, the mother, she doesn't have child care. She has no family there. She has no good paying job. So the court may look at that. Okay, you go back home and you'll have family. You have your house that you own. The child would be going back into a school district she already was in. It's all good stuff. So in this case, I'd be interested to see what the court would think about the relocation, and plus, whatever the father's employment status is and who he works with, would it be possible for the father to move? And if it's better off for the mother and the child to move, then they would, and then he would have extended visits, unless abuse was proven, of course. Like I do, I have the entire summer and stuff. But it was my decision.
You know what? It's like this. Just say it like this: in domestic relations court, in the family court. Okay, here's what it is. Here's all that's considered evidence. He hit me. Oh, he did. What a monster!
Yeah.
Protection order. You're not even there for that. So you know what? There's so many. Everybody's different in this aspect.
Oh yeah.
I mean, there's some people that think a little minor infraction, like, you know, I remember I was all butthurt about being 15, 20 minutes, you know, her being late with the kids. And, you know, I got all butthurt about that. And, you know, you got to understand something, that we're dealing with the system where these people, these actors in this system have purposely designed it to make it so you can be attacked without cause. They have training manuals on this shit. I have all kinds of PDFs. Every state has this.
Yep.
Every single state. We put together another team, an IT guys, you know. We put together another team. They've been working relentlessly on getting every single available state docket site for any kind of action in any kind of family court, all on one site.
And then you've got the organizations like the AFCC pushing gals, the people who invented the gal. Now they want to get psychologists to further litigation within family court when abuse needs to go to criminal court. But anyways, let's move on to question 2. Are you guys ready to play question 2 on?
Yeah, let's do it.
Judiciary. I'm going to try to figure out why you guys can't hear this question while it's playing, but for you, it'll probably just be silence for now. So just bear with me, then I'll ask the question.
It's inappropriate. It's the appearance of impropriety.
All right, so that was a quick one. Beautiful question, Rhonda. What is the appearance of impropriety? A, acting out in court. B, conflict of interest. C, abstain from all appearance of evil. D, abstain from all appearances in court.
D.
Abstain from all appearances in court.
D.
Incorrect.
Say okay. Here's the question. Beautiful. All right.
D or B?
Interest.
All right. What is appearance of impropriety? A, acting out in court. C, conflict of interest. C, abstain from all appearance of evil. D, abstain from all appearances in court. Appearance of impropriety.
Oh, okay. I
Yell out your
heard.
name.
Chris,
what
I
do
would
you think
say.
it is?
This one. What is this?
Chris, what do you think it is?
Me.
Go ahead.
A.
Incorrect. Who else has an answer?
Ante.
Me. Let's try. Is it B? Conflict of interest.
Yes.
Okay. I don't know if that was Neely or Ante.
It's Neely.
All right. Let's check the video answer.
I must be so foolish. I always thought that that was a conflict of interest, but it probably isn't anymore because, you know, we don't follow the real laws of the land anymore. That's nice.
So he's at a party with the judge who is overseeing my daughter's case, and then he works with the criminal judge's daughter. Who knows what was discussed at that party?
I can't hear
Who knows?
anymore.
It's inappropriate. It's the appearance of impropriety.
All right. The video answer was playing. If you don't hear anything, then just be quiet. And I don't know. I'm sorry. I don't know why it's not going through. That's one of the things that I spend a lot of time to make sure you guys can hear what's happening. And with this update, some wires must have been crossed. So it is both B and C. I would have taken either one. So the appearance of impropriety is a phrase referring to a situation which to a layperson without knowing the specific circumstances might seem to raise ethics questions. For instance, although a person might regularly and reliably collect money for her employer in her personal wallet and later give it to her, her putting it in her personal wallet may appear improper and give rise to suspicion. It is common business practice to avoid even the slight appearance of impropriety. According to some translations, the Bible in 1 Theologians 5:22 warns, abstain from all appearance of evil. So I would have taken conflict of interest or this Theologians if you are into the the Bible. Do you think that pictures of this lady's ex-husband with her former attorney, two of the judges, and then another picture of her ex-husband at a bar with the judge's daughter is appearance of impropriety?
Yes, absolutely.
Yeah. A huge conflict.
Hey, I got a picture of the judge and opposing counsel and an appellate judge picking it with another lawyer at a party. It don't matter.
There you go.
I got the judge and the lawyer meeting behind closed doors without me there talking about my case and having lunch at BW3.
I have an email too. I have emails. Proof that they
I have a photograph of the bitch claiming that she didn't have the kids. She posted it on Facebook. I have a photograph of her having the kids.
Wow. Freaking crazy.
And you know what? They said that doesn't matter.
Wow.
Is
it's really
I got the judge's email. Somehow of the conflict of interest before they violated my right to due process and didn't have me served. I have the email saying that, we got the order signed, so you can pick it up in the office. Yep, so.
Wow.
Yep.
Well, let's move on to question number 3. All right, you guys ready for question? So just...
I have a point now? Okay.
Yes, you have a point now. We have one for Chris, one for Neely. Question 3, so just be quiet through the video question since you can't hear it. I can't freaking believe that. All right, here we go.
Law is the science of what is good and just. If you can apply a science to a law, that is something that's recognizable by the court. They can take that thing and go, I can use this over here, I can use it here, and here. And what you've just done is you have provided a service to the court. Give them a solution that fixes the problem. And I'm not talking about, throw that son of a bitch in jail. Okay. That's not a solution. No. Okay, that's a punishment. That's a whole different animal.
All right, so the science of what is good and just, and provides to the court a solution rather than a punishment. A, termination of child support. B, case law. C, maximum of law. D, termination of parental rights. Something that provides...
Chris. Ante, it's maximum of law.
All right, I guess go ahead and just yell it out and say your answer. I think that's...
Chris
give
D.
that one to Ante. It is maximum
Dante
law.
says maximum.
So let me play the video question for everybody at home, please. All participants, be quiet.
And there is a maxim of law that clearly states, law is the science of what is good and just. A solution is something that can be used over and over and over and over and over again. As far as what's reasonable, you make a suggestion or a recommendation based on history, and make sure your history is accurate, because they will check. And if your history is accurate, your request will be deemed reasonable.
All right, so I'm just trying something here. Can you guys hear me still right now?
Yep.
Yeah.
Okay. That might have helped. I might have just made it so you guys could hear. So, yes, let me just go over here and do this for Ante. Congratulations. A legal maxim is an established principle or proposition. The Latin term is not found in Roman law with any meaning to that of a legal maxim. The attitude of early English commentators towards the maxim of law was they are described as of the same strength and effect in the law as statutes. Not only will the use of maxims be in deciding doubt and helping soundness of judgment, but further in gracing argument, in correcting unprofitable subtlety, and reducing the same to a more sound and substantial sense of law, in reclaiming vulgar errors, and generally in the amendment in some measure of the very nature and complexion of the whole law. In later times, less value has been attached to it, but both historically and practically we must place interest on the value of the maxim of law. For instance, when Jesus spoke to his accusers, he would justify himself by quoting law. First, he would quote God's law. Then he would quote the accuser's law and use that against them. Those were the beginnings of punishment fitting the crime, and in my opinion, perhaps one of the reasons he is the most historical figure to ever exist. And then the picture below is this young lady. One judge in Ohio gave this 18-year-old the choice to walk 30 miles in 48 hours or to spend 30 days in jail as a punishment for taking a cab the same distance without paying. So that's an example of the maxim of law, creating a punishment that will work and may be usable repeatedly. That's what Chris was talking about, and there's some many different examples and where it came from. So let's go right into...
There's a judge that does that kind of stuff all the time up here too, and everybody loves him for it.
Yeah, it makes sense. So, why put this
he does
girl...
it all the time. He's always on the news.
Why hold the punishment to the letter of the law? Why? What good is it going to do for this girl to go to jail for 30 days? Nothing. It's just going to piss her off. Make her work. Make her see what 30 miles really is. I don't think she'll ever do it again. But if you put her in jail, you might lead her on a path which is not good. Not a good path.
Destruction.
Right, a path of destruction. Yep. Exactly, Chris. Let's go on to question number 4, and let me know if you guys can hear this. I might have just changed it. Hopefully we're all set.
There shall be no imprisonment for debt. Those are all things that you can put in your paperwork, because they have to answer your paperwork.
Still can't hear it?
No. I'm only on my iPhone. I don't got the show or anything on.
Okay. Well, you should be able to hear it through Zoom. I don't know why you're not hearing it.
Yeah, it's not playing through Zoom.
Huh.
That's okay. We can still play.
All right. All right, let me play this for everybody at home, and then I'll ask you the question.
There shall be no imprisonment for debt. Those are all things that you can put in your paperwork, because they have to answer your paperwork. And anything that has not been rebutted stands as truth. Is this not a debt? Well, if it's not a debt, then what is it? But I know that what they try to pull on people is, oh, well, this isn't a debt, this is support. Okay, what is support? What are you asking? Right. Well, you have to pay that. Pay what? Well, you have to pay the support. With what? With money. Oh, but you just said it wasn't a debt because this is only good. There's a case out there, Montgomery Ward versus, was it Eugene something? But his wife went out and bought stuff on a credit card. And then he went to court and said, well, look, I don't even know about this. I didn't know she bought this stuff. Well, isn't this your wife? And, yeah. So, okay, you owe the debt. Okay, well, how much? $5,000. $5,000 of what? If I ask you for 5 pounds, you're going to go 5 pounds of what? And he said, I don't care what you pay him with it.
All right, so how was the fine paid in the case of Montgomery Ward versus Eugene Glazer? A, time served in jail. B, magic beanstalk beans. C, walk 30 miles in 48 hours. Or D, coffee beans.
Ante. Hey,
Chris.
I heard Ante first. Ante, what's your answer?
Hey.
Incorrect.
Fine, sir.
Incorrect.
Oh.
Chris.
Can you repeat the question?
How was the
'Cause I didn't
fine? How was the fine paid in the case of Montgomery Ward versus Eugene Glazer? Chris, you're up.
Can you repeat the question?
How was the fine paid? How was the fine paid in the case of Montgomery Ward versus Eugene Glazer? A, time served in jail. B, magic beanstalk beans. C, walk 30 miles in 48 hours. Or D, coffee beans.
C.
C?
Neely.
Incorrect.
I know
Neely.
the answer. I know the answer.
What is it, Neely?
What's the answer?
Coffee beans. Coffee beans.
You are correct. Congratulations. And let's go to the video answer.
$5,000 of what? If I ask you for 5 pounds, you're going to go 5 pounds of what? And he said, I don't care what you pay him with, coffee beans. The gentleman went down to the store, 1 for 1 coffee bean per dollar, and he paid Montgomery Ward in coffee beans.
What was that?
I think they could
Even
hear
though
it.
the Constitution says gold and silver shall be the fixed weights and measures and the standard that we all go by. So if they abolish that, then what actually we do?
All right, I muted you guys so everybody at home could listen to the video without hearing the mumbles. I'm sorry that you can't hear it.
Oh, sorry. I
right.
wasn't aware I could be heard.
Yes. So I'll just mute you guys for the rest of it. I'll be figuring this out later. So if you guys can get to this website, it's Mainer. If you're not aware, if you live in Maine, you're called a Mainer. So MainerPublicMailAlert.com is where I found this affidavit on inability to pay cost, fees, obligation, fine. And I posted this on Facebook today or yesterday. Very interesting read. You should all read it. But it cites what happened in this story that Kirk shared with us. And I'll read it to you right here. And there's also something at the bottom I want to show you about signatures. But when pressured to identify the form of money to be used to settle a judgment, the 52nd 3rd Judicial District Court of Michigan, Honorable Justice James P. Sheely presiding, ruled that coffee beans was money, storming out of the courtroom shouting, "I don't care if you pay it in coffee beans, just so long as you pay it." Montgomery Ward versus Eugene Glazer in 1982, the judge, as in many intentionally unpublished state and federal cases, he could not bring himself to violate the law in open court on record and declare Federal Reserve notes, our dollar bill, to be lawful or legal tender in payment of debts outside exclusive federal territorial jurisdictions. So Glazer, a Michigan native, paid the settlement, court costs, and a few of his own other debts in freaking coffee beans, and still carries a large sack of them around with him wherever he goes today. 1982, paid in coffee beans. They're a little bit more expensive today. I don't know if I could afford a coffee bean to pay off $30K, but down at the bottom.
Hey, it's up to you to sell the plant for how much you believe it's worth.
Right.
I'm so going to try to pull that in court. I'm going to hand the bitch coffee beans. I'm like, here's your $40,000 in legal fees paid in coffee beans. You're paid in full.
Don't say bitch anymore, but please. But
oh, sorry.
That's all right.
Support is not monetary. It's not money. That's not what support is. Support is caring about your, love.
That is.
Oh no,
doing all the
$40
for 40 grand in legal fees.
Right. Well,
has nothing to do with money. Nothing at all.
You need to read this. The Maynard Public Mailer, and at the bottom it shows right down here how this person signed this document. So he goes on with 3 paragraphs about how what he's going to say is him, and by him giving it to them with just his written signature with this paragraph attached right here, if you can see my cursor, that is his signature right there, a notarized signature. So please read this article. I think it's freaking genius, and it talks exactly about the story that Kirk shared with us on Monday. And let's get right into question number 5. Are you guys ready?
Let's do it.
All right, so just be quiet during the question, then I'll ask you the question after the video.
Okay. If they charge you with a statute and you find out that there's a case that statute was already tested and the statute failed, you just say, hey, this is...
All right. That was a short video question. In a case in which there has been a final judgment and is no longer subject to appeal, the legal doctrine meant to bar or preclude continued litigation. A, res judicata. B, claim preclusion. C, contra legem. D, actus reus.
Neely.
Neely, what is your answer?
Is it A?
Let's see. Let's see here. We need that, and we need yes. Holy crap, Neely, you have a 2-point lead over everybody. Congratulations. Let's go to the video answer.
This is res judicata. You can't try me for this. It's already been, this went to the Supreme Court, and the Supreme Court said you can't do this. So why are we having this conversation? Motion to dismiss for lack of personal jurisdiction.
All right, so that was a pretty quick video answer too. That was from Chris Hallett. So this is res judicata, also known as claim preclusion. So either A or B, I would have taken this time, is the Latin term for a matter already judged and refers to both of these concepts. One, in both civil law and common law legal systems, a case in which there has been a final judgment and is no longer subject to appeal. 2, the legal doctrine meant to bar or preclude continued litigation of a case on the same issues between the same parties. So in this latter usage, the term is synonymous with preclusion. In the case of res judicata, the matter cannot be raised again, either in the same court or in a different court. A court will use res judicata to deny reconsideration of a matter. The doctrine of res judicata is a method of preventing injustice to the parties of a case supposedly finished, but perhaps also, or mostly, a way of avoiding unnecessary waste of resources in the court system. Res judicata does not merely prevent future judgments from contradicting earlier ones, but also prevents litigants from multiplying judgments and confusion. So congratulations, Neely. Let's move right on to the second to last question. Question number 6. You guys ready?
Yep.
Yes.
Here we go. And even the ADA, from what I understand, is starting to accept the term legal abuse syndrome. How powerful could they be in helping us end our current judicial system? So the question there was, that was with the Honorable Mary Elizabeth Bullock, and she was an EEOC federal court judge in the 9th Circuit over there in California, and we talked a lot about the ADA because she worked for the Equal Employment Opportunity Commission, and when she needed help, they denied her. So then she had to sue. The judge of that federal EEOC court then sued the EEOC commission. Isn't that ironic? So how can the ADA help us in CPS and family court cases? A, by giving everyone affected ADA status. B, by acknowledging that legal abuse system is a form of PTSD. C, by advocating against the legal profession. Or D, by becoming the new judiciary. It's very hard to... Ante.
B.
Which one?
Yep.
B, as in boy.
All right, I think you are. That is 2 for Ante, 3 for Neely, and 1 for Chris. And let's go on to the video answer, so just bear with me, guys. I'm going to put you on mute just for a second.
I wrote an article about the ADA, about the problems of being a Schedule A employee. Oh, sure, upper management, the upper echelons have conferences here and there. When they get you and they put you in an office, that office hasn't a clue what to do with you. There needs to be a separate court just to hear accommodation requests.
So this is and sometimes I want to throw a question in there, even though there might not be a perfect answer, but this is something that we can all do. So I needed to talk about this. As the Honorable Mary Elizabeth Bullock says, though you may have a case under the ADA standard, it could take years because of the current structure. There would need to be a separate federal court to hear the thousands of requests in a timely manner. I mean, she went 13 years before her case was finalized, and in that time, they had kicked her off, took her license, and she couldn't even read a book anymore without serious help. But if they had helped her right off the bat 13 years prior, she'd be fine today. So if we can determine that, in fact, the courts and CPS are creating disabled parents and children through legal abuse system, PTSD, ADA advocates will start stepping in under Section 504 of the Rehabilitation Act of '73 and Title II of the Americans with Disability Act of 1990. Now,
I'm disabled.
What?
I'm disabled.
You are? So
Yes.
you'd be interested in this. You should become an ADA advocate. So with your ADA advocate certification, you can contribute to a larger social cause by protecting civil rights and functionality of litigants with disabilities. Through your efforts, you can...
Brother, that's something that I'm going to say it just like this, because a lot of people don't know this about me. One fact about me is I have epilepsy. I've been diagnosed with that, and there isn't, I have grand mal seizures, so I'm also...
So do I.
The awareness thing. So believe me, I've been part of Cleveland Clinic's 125 case studies because I could recall what's going on during my seizure. I guess they found that pretty amazing.
Wow.
So they wanted to study me. So, I understand all about that. And that's why I encourage such people like Tanya Myers, how she was out in Iowa getting her cert. I'm encouraging that by all means. You know why? Because that's something every level of court in the government has to recognize.
Yes. Yes, that's the thing.
There is. If they say no to that, they are saying no to any type of federal funding.
Yep.
That includes for the police. That includes for the streets. That includes for the courts.
Yep. So this equal access advocates is a way to become a certified ADA advocate. This is something we can all do very easily, and through your efforts, you can ensure that these litigants have equal access to legal resources and they get their fair hearing under the Americans with Disabilities Act as amended in 2008. So go to equalaccessadvocates.com to become an equal access advocate. I think everybody in the family law reform community should become an equal access advocate. And there's a form right there. Just go to that website, fill it out, become an advocate, a certified one.
And you know what? And here's another big play for everybody, because you got to understand they're going to use it against you. If you ever been diagnosed with PTSD, that is now recognized by the APA, and it's always included in disabilities. You really want to get the nitty-gritty, detailed stuff about different things of ADA without the least bit of hesitation in giving it to you, simply contact the Cleveland Clinic. They will even offer you classes for you to come in, and they will teach you the classes, because everybody goes by what the Cleveland Clinic says.
Yeah.
Everyone.
Yeah.
They set the standard for workman's comp. They set the standard for everything, and that's why they're number one in the world.
Yeah.
So with that being said, they will tell you. They'll give you like tutorials. They'll give you videos to watch. Ask them. They'll happily tell you.
Yeah, I think the ADA is one path that we haven't been researching enough. I think if we were all to become ADA advocates, and if the ADA then we help the ADA help them realize that I have PTSD from the legal abuse I received in the family court. At that point, the ADA will help us end the family court.
Listen, and you have to understand, we're doing so under executive order because Donald Trump told us we have to. As citizens of this country, we have to step up and fix the problems of this country. And we have an executive order stating that. So we're saying under executive order, the people do not have representation in this area. I seek to be an advocate for the people. We come in as a branch of the government, as we, the people, and we step in as the first branch of government with APA certifications that they have to recognize, and we advocate for our people.
Amen. Let's do it. Let's get this done this week. Let's start seeing these certificates
Brother,
online.
It's all part of my case. Every ounce of it.
Yeah,
that's what I'm bringing to the table. I'm asking for that reform.
Yep.
Yes. I am bringing an 83 action, and I'm asking for injunctive relief, and that's one of the ways I'm asking for it.
Yeah, sometimes I open up the Amber and Steven group, and I'm just like, I get overwhelmed, and you just got to sit there and start reading. It's almost as good as reading some of these law books sometimes. Better in some instances.
And people, you got to understand something. I'm going to be honest with everybody. I tell everybody the same thing if they ask me. First and foremost, read the Constitution of the United States of America.
Yep.
Second thing, read the Declaration of Independence.
Yep.
Now, whether this offends people, I don't care, but before you read either one of those, why don't you take time out, look up and say, help, and then, continue reading, because you got to pay respects to the man upstairs. Okay? God created the law. The law is not bad. The actors are. Got to protect bad actors, not the good actors.
It's a very good point because, whether I believe in a higher power. I believe that there is a God. I don't believe that he is a human form. We are ants to him. Just like we can't imagine what's in an ant's head. An ant can't imagine what's in our head. We can't fathom the time and space that God might be. Now, was Jesus the hand of God? Maybe, maybe not. But he was a very intelligent individual, and he spoke God's law. You are to treat man, basically the golden rule, the way you treat yourself. You treat people with respect and dignity. And Jesus was the first person to start getting the punishments to fit the crime. It didn't happen he had to die for this to start happening. It wasn't until Christianity took a hold that this started to really happen, but obviously not 100%. Not really until Roman law, Greek democracy all mixed together. You got the English form of law, and then now our republic. And you have to remember, our country, when it comes to law, is not a democracy by any stretch. It's a republic, for the people.
Yep.
The only part that we are a democracy is when we vote on something. And most of these judges we don't vote on. Most of them are appointed. especially in family court. So let's go on. We have one last. There's 7 questions with 2 people. It would be a tiebreaker question with 3. I'm afraid this would knock Chris out, but that's okay, Chris. I'll still send you a shirt if you send me your address. Neely, if Ante doesn't get this correct, then you take it by a landslide. Ante, if you get this correct, then it's going to have to be a tie because I don't have an 8th question. So let's get right into the tiebreaker question on Judiciary. All right.
I wrote it.
Up to 500 children went missing in the Washington, D.C. area. And that was right around the time of Pizzagate rally. All right, so this, I needed to just I needed to close the door on this whole, what the hell is Pizzagate? So that was, you know, with Mary Elizabeth, she's very into child trafficking right now, and I wanted to see what she thought about Pizzagate. I wanted to see what Kirk thought about what Pizzagate was. So what the hell is Pizzagate anyways? A supposed underground ring of restaurants trafficking children. B, an abbreviation for child trafficking. C, a reference to Nixon's Watergate scandal. D, Richard Nixon and Anthony Weiner's last meeting.
Neely, it's A.
A, Neely, you are the winner. Oh my goodness. Yay. Wow, Neely. But because I have a somewhat plethora of these shirts, I'd be more than happy to send all 3 of you a shirt for participating. Just send me your address in a PM if you're comfortable with that, or a P.O. box. I have a P.O. box that I use.
Yep.
So let's go right on to the video answer. I'll just mute you guys one more time and be done with the muting. Hold on.
You know, it's about pizza, right?
Having an attack on something that feels like your family is very painful. So I stopped by to wave, even though they're closed. I wanted to walk by and wave and just a word of support. You know, they're innocent bystanders in an atmosphere that is very frightening.
Fake news matters a lot to me in general, and I've been arguing for a while now that there were real-world consequences of it. I hope that the digital platforms that have allowed this kind of information to spread because they want to be neutral take more action and understand that, you know, no blood got spilled on their hands today, but some blood can definitely get spilled on their hands tomorrow.
Several other businesses on the same block have been targets.
The calls that start coming in, they start jamming our phone lines, claiming that we are involved in that child sex ring with Comet and Bucks and some Pizzagate, whatever it was, and threatening us. You know, I got 2 calls, nasty calls, and they threatened to come and blow my head off and blow the store and the organization that's involved in this ring. I didn't take him seriously, and that was it up until yesterday. That's what happened, and it's unfortunate and sad situation. I'm just an independent pop and mom kind of shop, trying to earn a decent living or an honest living. That's all we do here. We've been 25 years here, and we have a lot of this neighborhood. You know, this kind of influential neighborhood. I know we have a lot of support from our regular customers, but at the meantime, we lost a lot of business.
So that was one of the businesses that got a lot of like hate mail, threatening phone calls. So Pizzagate, the belief that code words and satanic symbols point to a sword underground along an ordinary retail strip in the nation's capital, stemming from Hillary Clinton's deleted emails. The time frame here is important because around the same time everyone was talking about Anthony Weiner's Wiener, Comet Ping Pong, a pizza restaurant, held a fundraiser for Hillary's campaign. What was false were the rumors that crisscrossed the globe about this charming little pizza place that features ping pong tables in its back room. The story of Pizzagate is about what is fake and what is real. It's a tale of a scandal that never really happened. It brought more attention to child sex trafficking, but discredited the stories at the same time. If it were not for Twitter bots retweeting the hashtag Pizzagate thousands and thousands of times a day, most likely it would have never been given any attention. So I'd like people to kind of forget about this phenomenon called Pizzagate and maybe pick up this book that the Honorable Mary Elizabeth Bullock mentioned or showed us, Epidemic, America's Trade in Child Rape. So forget about Pizzagate and start reading this. That's, I think, where we should start. And we need to try to tie this part into family law reform, because we're about the children's fundamental rights to both parents above the state, which means above the country, above any other state agency or country. This is something we should all research a little bit and bring into the folds of what we are doing in our efforts. So there we go. There's the whole game. I have a chat room here, but since I'm on Facebook probation, I can't show you any of the Facebook comments. I'm very restricted. So these are all comments from Periscope. Looks like they're from overseas. Regard, hi, question mark. Hadge, hey, regard, hi. Those are all my comments I got from the show. So, back to this one. Yes, Chris.
I sent you my address and
all right,
city and state.
Awesome, bro. I'll send you a shirt out Monday.
Okay.
I appreciate it, and I really appreciate everybody's time. And I apologize again for the audio problems. When I first started setting this platform up, it was a huge deal for me for you guys to be able to hear everything that I play. And so whatever update I just got on OBS screwed that up, so I'm going to have to start digging into what wire got disconnected, what virtual wire got disconnected, because that's the real technical part of all of this. Anybody can play OBS, but to have an interactive game show, certain things need to be able to work, like you guys being able to hear what I'm playing. And you can hear the music, you can hear the time music, all of that, no problem. Just you can't hear the media source on OBS. So it's got to be an OBS problem. But thank you guys so much for playing.
Thank you for
and make sure I get your addresses or PO boxes. I'll send you out a shirt and a size. I've got regular large, extra large, which is like a unisex, and then I have a woman's medium, which is more tailored. So get those out to me. Is there anything that you guys would like to say? Advice, statements?
Hey Ted.
Yes, sir.
Do you have it in medium?
I don't have a medium man's. Large is the smallest in men's, or in unisex.
Okay.
So like I bought these things.
Yeah, you could send me an XL.
XL. All right.
Yeah, it's gonna cost a little.
I just want to tell you, Ted. I want to tell you, Ted. Thank you for what you do. I really enjoyed meeting you at the Million Parent March, and I've been really busy. Sorry I haven't been able to back out to you. But I just want to say I appreciate everybody for what they're doing and exposing the truth, because it's so time that the law of the land applies. It's so time. It's so past. And so we have to help as many people as we can, because people just don't understand it.
Right. And that's
this
show is like hopefully attention grabbing enough, even though it's somewhat silly, but at the same time reiterating information in a compact way, in a fun, interactive way, I hope we'll get more people vocal, because now the 14 viewers watching will see that, all right, there's 4 of us on here willing to talk about what they went through. There's no reason to be embarrassed or ashamed. Millions of us are going through the same thing.
Look, very simple. There are strength in numbers, and the more numbers we present, you know, hey, when the emperor was threatened by the mob in Rome, what happened? The emperor gave the mob what they wanted. You know, so...
I want to actually say something and get your thoughts on it. The story of Daniel in the lion's den, when they threw Daniel in the lion's den, I was reading that scripture and God brought it to me. And it looks like that he's, the Pharisees, which would be now the lawyers and, you know, other people, but at the time then it was the Pharisees, made the king sign this ex parte order where he couldn't break it. And because the king did not want to throw, the judge, the king, did not want to throw Daniel in the lion's den, but he had to do it because that's what the law said at that time. And so when he was thrown into the lion's den, and then the next morning when he came and the lions had not killed Daniel, the king, the judge, actually threw all the Pharisees into the lion's den and they killed him. So I'm just waiting, and I would like you to look at that.
Listen, I'll just tell you like this, and this is exactly what I tell everybody. You know, and it's been told to me, and there's wisdom in it. And I'm glad you brought that story up, because there's great wisdom in it. Number one, Daniel could have sat there blaming everybody, feeling sorry for himself. Oh, get eaten up by lions. He didn't do that. What was Daniel doing? He was sitting there. He was petting them. Okay? He was sitting there petting death, looking at death and seeing it for what it was. And he was okay with that because he was at peace with God. And he knows he didn't do anything wrong. Now, what happened? Daniel didn't come out blaming the judge who had to pass the ruling. He didn't blame the king, because the king was forced. But you know what? That's the same mindset you should enter federal court with. Don't attack the judge. Attack the bad actors. Yep. Let everybody else sort their ways out. Yeah, okay? And that's a great mindset to have, and you just gave the scripture backing for it. So with that mindset, don't attack the king. Attack the people who lied to the king, forcing the king to invoke the law.
Exactly. So it's so much more deeper, and we just gotta let everybody know, and everything that you're doing, Ted, you know, is what you're right where you're supposed to be doing, you know. And so I just wanted to say that. Thank you.
Thank you, Neely. Yeah, I agree, and Chris's take on things where you try to get the judges on your side in a way that says, you know, we've all been duped by these incentives, by these legislators creating a situation that only benefits themselves. Most judges don't want to be in family court. Some of them are appointed, but a lot of them. It's funny,
yeah.
Yeah.
I was at a child support hearing in Kentucky because they served me with the uniform. I can't remember the law exactly, or what the actual act is, and I had pulled it up, so I was ready and prepared. So South Carolina came to Kentucky now and did under this act, and they're now Kentucky is getting the child support for South Carolina. But anyways, I was in there and I was in court and I had the law pulled up, and the judge was like looking at me like, oh my gosh, she knows what she's talking about. I mean, I was going off. I went off on the prosecutor, and I just accepted it. I said, you know what? We're just going to accept it. The judge respected me so much. And I said, he knew that I knew but he had to follow the law. Like, it was the law. I mean, it's the laws that are in place that in these systems, in these court systems, that are the ones that, so the laws have to be changed.
Yeah, and as you go up the higher courts, you'll see the judges lean more towards your constitutional rights than these doctrines that don't really mean anything. some of the doctrines help, some of them hurt. I can't even
Parents patri.
Yeah, patria. Parents patria is horrible.
It's like this. You just gotta know. You gotta know what argument you're arguing in what court. If you're sitting here trying to argue facts and evidence, you're going to argue that till you're blue in the face in an administrative court. You know, that's where people. You know, I myself have even done it because, you know, I call it out for the BS that it is, and I label it for what it is. And when I write out my affidavit, I simply say, I believe this person committed fraud by doing it this way. And that's it. Because guess what? Then they can't sit here and say, oh, you said that. You said, I believe that. So what? Here's my reasoning for believing it. The attest exhibits.
And like Kurt said, if you have very few times that you'll be able to directly talk to the judge. So you want to make sure that you have all this information down legally in paper. That way they have to address it. They have to rebut it, refute it. There has to be a rebuttal in order to get rid of the paperwork. They have to look at it. If they don't, that's automatically a deprivation of rights. Title 42, Section 1983, or the other one, Title 18, Section 242. And I'm going to hopefully get Kirk and
my
Chris.
advice is to stay away. My advice is to stay away from 241, 242. First executed in 1983, in 1985, and in 1986. After you execute the 85, 86, which proves a conspiracy and a collusion, which the burden of proof is less than it is in the criminal way, you win favor already by proving that. And let the 85, 86 roll into a prosecutorial measure with the evidence that you supply in the appendix of exhibits. If we try coming at them with RICO without having 50 cases in each state, it's not going to work. It's shot out.
Is that RICO?
That's what I'm going to start working on. I want to start working on. That's what I'm going to start working on, is getting Terrence take my case to see. I haven't actually gone in federal yet, and no one actually even knows my whole story yet. So, and I'm.
You know what? I'll tell you just like this. I guarantee you, our stories are very similar. A lot of the same injustices.
Downstairs.
The details themselves. The details themselves are different, but you know what? The same actions have happened, regardless.
Yep.
Bottom line,
and
we don't have our
need
children equally.
massive people. We need to go and get massive people that have been, you know, like doing, you know, get 50 or 100 families, 200 families.
Listen, to bring a RICO action, you're going to need 50, minimum 50 in each state.
Yep.
In each state, the same action too, same cause, same violation.
Well,
and you know what? I'm going to say it like this. People have to understand that 18643, subsection 643, chapter, or 18 USC, subsection 643, clearly defines a prosecutorial measure. You put that in the combination with Article 1, Section 9, Clause 8 of the Constitution of the United States of America, and also bring in the Declaration of Independence into your argument, and you present your story, and you don't attack a single judge.
Nope. Yeah.
You attack the bad actors and the things that they did wrong and the defective practices of law, and you let the judges figure out the rest.
Yep.
They're not stupid. They are judges. Whether we hate them or not, we have to give them the respect that they are a judge and they've been around a while and they know the law.
And that's what the judge, he said to me when he looked at me, I looked at him and I said, I just want you to know, that I know this is what I've been fighting for and I haven't seen my little girl. And he said, I wish you all the best luck. I want you to go back to South Carolina and do what you need to do to get her. And he said, and I said, I would love to be a family court attorney. I looked at him, I said that, and he said, be careful what you ask for.
Yep.
And I thought about it. I said, why? I said, why is he, I can't believe that he's saying, he knows. Yeah.
We have Kirk Pendergrass on the phone with us. Hey, Kirk. Oh, you're on camera, too. All right, let's see what I can do to get you on here. How are you, bro?
I'm doing good.
Good. So, how are you doing tonight?
Hanging in there. I've been.
What's up, brother?
Tired. Crazy. Man, last couple of days has just been rough.
Yeah. I'm gonna try to find a preset here. Oh, whoops.
What she would tell me is I have.
Oops, wrong one.
What's been going on, brother? Can you hear me?
Yeah. Yeah, I'm watching over here too.
So I was just about to wrap things up. I'm trying to find. I could find a. I don't have a preset anymore on this. But I was just.
I don't know all that.
I was just about to wrap things up, but if there's anything you want to talk about, Kirk, please.
Yeah, you know, with the deal that we just did on that breaking news, I'm going to turn this down here. So
yeah. Thank you.
I didn't know I was actually hooked in all the way. What we brought out there with the breaking news with Jeff Sessions and all that stuff.
Mm-hmm.
This is a new era. Okay, Trump has brought back the de jure form of government. Okay, a just form of government. Forget everything that you've been told. Forget every case law that you have read, and start reading the actual law. Declaration of Independence, the Constitution for the United States of America, the Bill of Rights, and your state constitution. Okay, that is the rule of law. What it says is golden, and there ain't nothing that can beat it. Okay,
but sometimes you have to go
understand, and I mean this literally in the legal, lawful term. Understand is you stand under or stand in agreement with the words that are written right here in the Constitution, in the Declaration of Independence. What it says, nothing can beat this. Now, the thing we have to understand, and this isn't just family courts, and this is the reason why we have to understand that this isn't just family courts. The admiralty jurisdiction was extended back onto the land in 1845 by congressional act. Okay? Every single court, aside from federal courts, is under admiralty jurisdiction, enforcing maritime law, the law of the sea, the law of contract. So you have your birth certificate. That's the first contract. Now, through the 14th Amendment, that's what turns us all into slaves. All of us. So that's just my little bit on the 14th Amendment turning us into slaves. It's not what you think it is.
Right.
Okay?
A lot of us don't like the 14th Amendment.
Yeah, it's an unlawful act. It was never even fully ratified.
Right.
Just so you know. It's not even a lawful amendment to the Constitution.
Wow.
Now, getting back to the rule of law and reading this rule of law, knowing the fact that your first court that you're going, and this is how we're going to defeat these courts, one by one, and it only takes one. Okay, and I'm actually, oh man, I've got like 4 or 5 different cases in my head that I want to argue and bring all the way to the Supreme Court of the United States about if it needs to go that far, more than likely. One of them being the marriage contract. That's an unlawful contract. That is a religious act protected by the First Amendment, and you can't convert that right into a privilege, license it, and attach a fee to it. That is a common law right. It comes from the Bible. And it is a sacred vow between a man and a woman. There's one case. Okay? Second Amendment. It says the right of the people shall. Shall is a very powerful word because it must, or in this case, must not be infringed. Okay? When we're talking about bills of rights, they are self-executing, such as the Second Amendment is very clear in its wording. The right of the people shall not be infringed. What that actually means is there's absolutely zero legislative authority. There is absolutely zero executive authority. There is absolutely zero judicial authority to make any policy, rule, or regulation and enforce that as law, because there is no authority. That's constitutional law. When it says shall, and the word says shall not be infringed, that is a direct self-executing right. Does not allow any delegation of authority. So again, when you go into these first courts that we go into, you have to make your arguments. You have to file your paperwork. Okay, you got to raise your hand to be heard. That's part of due process of law. But the other part to due process of law, and there's more than one part to due process of law, you have the right to an appeal whatever that judge says, thinks. I don't care. You have to file your paperwork. You have to make your demands. Okay? Anytime you're going to be deprived of your life, your liberty, or your property, you have the right to a trial by jury. And then you have the right to ask, okay, what is the nature and cause of action here? Because I need to know what kind of rules we're following under here. So when we go with the best interest of the child, that's supposed to be criminal in nature, right? Because that falls under domestic violence or murder. That would be one of the 10 commandments, thou shalt not murder. So anything that kind of falls under murder is violence, okay? And that's what it is when you're coming to the child's best interest, is violence, is it not? So that is criminal in nature. And my own statutory law, my code, specifically lays that out. And it says that this is supposed to be handled in this governmental compelling interest, meeting the strict scrutiny standard, okay? That is actually legitimate. That's out there. This parens patriae is the best interest of the child and must be dealt with through criminal rules of procedure, not in a family law court. There is no jurisdiction there. It must be done in a criminal court. So if you're not in a criminal court, it doesn't matter. Go ahead, Ante. You had a question there?
Oh, no, I'm just sitting here listening.
Okay.
See, the biggest thing, like in my case, what I did is I hit him with the status of affidavit of person. I also challenged the standing, and I also challenged the jurisdiction. One other thing that I did is I put in a change of venue. I put in a change of venue to change the venue of the court to an Article 3 proceeding. Now, here's the funny thing about it. I also informed the court in that change of venue of the federal lawsuit. And I put in a motion for the court to stay all its judgment entries, grant me equal access to my children, completely restore all my physical and legal custody of them. And I said, until federal supplemental relief is over. So I'm giving them something reasonable. I searched out the Ohio Civil Rules of Procedure. Rule 3, paragraph D, states that since this is an issue that this court doesn't have jurisdiction over, well, it needs to be heard before we hear anything else. And if the state can't offer the proper forum, then we have to go out of the state. In this case, it's going to the federal court. With the relief or remedies and using their own rules that they have, you can pull it out of every single state court into a federal court. And really, the winning argument here is simply based on emoluments violations, 18 U.S.C. subsection 643. I hit them with the Title 42, U.S.C. 1983, 85, 86. And then just turn their own filing in against them. And that is your evidence.
Right. So, which is what I want people to understand. And I'm going to go back over this Monday night, but I'm going to do a little bit more here on Monday night. The basic concept of due process of law. Notice an opportunity to be heard. You have to file your paperwork. You file your paperwork. You make your arguments. You make your statements. You make your claims. And you let that first judge do whatever they want to do. Okay? But you have to create the record for the appellate court to look at, for the federal court to look at. And now you're not moving this case to federal court. unless you're under, and I can't remember the exact sightings. There might be somebody out there that does. I think it's in Title 28 in the United States Code. I just can't remember the section off the top of my head right now. But it has to be filed in the first 21 days, and then you can move your case to federal court. Okay? What I'm talking about is when you file your paperwork, your notice of hearing, you want to be heard, you know, you're suppressing the evidence, or it's a motion for dismissal like everybody else does. When you go to federal court, they'll file a Rule 12b motion against you. It's exactly the same thing, only we need to be doing the flip side of that. We need to be filing the motion for dismissal, okay? And you have to look at your rules of procedure. It's in there. It's all there. All you have to do is read it, okay? So read your rules of procedure depending on what court you're in, whether you're in the family court, civil court, criminal court, whatever, okay? There's rules of procedure for every court that they have, and you'll have an affirmative defenses in there, objections and affirmative defenses. It'll give you the list of the grounds. So pursuant to rule blah 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 blah, this right here, whatever, okay, that's the jurisdiction that the court has to hear it. Even though it's an unlawful court, you still have to give the court that you're in the jurisdiction to hear the subject matter.
Right.
So object to the jurisdiction, obviously, under personal jurisdiction, which falls back to the affidavit of status of who you are. You're a man on the land, sui juris, in propria persona. That's pro per, not pro se. Okay, in propria persona, in your proper person.
You would suggest
okay?
going pro per rather than pro se?
Well,
in legal language, I'll speak for Ohio. They acknowledge it as one and the same when you do it like that. They don't have any rulings on, you know, in propria persona, and they don't have any rulings on sui juris.
I would imagine that some judges might view it as the same thing, but other judges might be like, oh, he knows the difference.
You folks aren't understanding.
Yep.
I don't care what they think. Just like Sessions said, it says what it says. And I'm going to add, ignorance of the law is no excuse. If you don't know what that means, that's not my problem. Right. I know what it means. And you want to violate my rights, actually it's not violate, it's deprive. You have to use the correct terms, okay? Legal terms. It's a word game. Right. Always a word game when you go into court with these people.
I think I may have fixed my audio
you have to know
issue.
What they mean. You got to grab a hold of one of these books right here. Okay, Black's Law Dictionary, 6th edition. I have my Black's Law Dictionary, 9th edition, sitting right here too. Okay.
Black's Law 10th, Black's Law 4th. I got the O'Connors too. This O'Connors is pretty kick-ass.
Let me know if you guys can, since everybody's on still. Will you guys tell me if you can hear this? And if you, well, you'll be able to see it in like 10 seconds. Just here we go.
$5,000 of what? If I ask you for 5 pounds, you're going to go 5 pounds of what?
All right.
And he said, I don't care what you pay him with the coffee beans. The gentleman went down to the store, 1 for 1, 1 coffee bean per $1, and he paid Montgomery Ward in coffee beans. That's a funny deal.
All right, so I'm glad I got that figured out. Jesus, I can't.
See, another thing that I figured out, you know, with the aid of others who also looked it up too. I went through individual states and seen if the states had any context of anything about something called emoluments violations. Well, in my research, I have discovered that no state has such a thing. So when you put down 18 U.S.C. subsection 643, you / and type in or write in emoluments violations, because the Constitution recognizes it, the federal government recognizes it, but the states, are they refusing to? And this is where you could get the unjust enrichment that they all claim, you know, that they had, you know, they try to claim jurisdiction where they had none. You sit there and just shoot them down right then and there, you know, and just poke holes in their ship and watch them sink like the Titanic.
There you go. Well, I'm gonna wrap up this show for tonight. If you guys want to hold on for a second, we can talk as soon as it's over.
Yeah, because I've invited a bunch of people.
Oh, you did.
All right, yeah, go ahead, wrap it up. I'll hang out. I'm gonna go.
I was gonna read this in proprietary persona.
Okay, let's read it, and then I'll wrap this up, and then we can talk off the broadcast.
This essentially, this establishes what jurisdiction you consent to. Remember, we're a republic by consent only. So, in propria persona, in one's own proper person, it was formerly a rule in pleading. Okay, that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by attorney, they admit the jurisdiction, as an attorney is an officer of the court, and he is presumed to plead after having obtained leave, which admits the jurisdiction. So when you hire an attorney, not only are they to attorn you, because that's the root word of attorney is attorn, which is take your property and give it to somebody else. In propria persona, and we'll get to do that. And the attorney goes in and admits the jurisdiction right for you, okay, and then takes leave, which means everything that happens from here on out happens to this guy over here. And I'm taking all of his stuff. I'm in charge of it now, and I'll give it to whoever you want me to give it to. As the attorney, as an officer of the court, I'm here to assist the court in extracting your funds and property. And I mean, that's it. There's another one, property. Right. Look up the word property. What does property mean? Property means unalienable rights. Yeah.
And that's why, like, it's hard to determine.
The Declaration of Independence is your unalienable rights. Sorry, Ted.
No, by that saying I came up with, that children have a fundamental right to both parents above the state, that could also be termed in property, that children are property of the parents equally above the state. And I haven't determined which way is better. Some people think the one way, some people think the other way. I'm not exactly sure yet which way is best, but we're going to get there. Please, everybody, hang out just for a second while I wrap this up. Let me just, why is this? Oh, here we go. So, don't forget, everybody, Monday, 8 p.m. Eastern, 7 p.m. Central, 6 p.m. Mountain, 5 p.m. Pacific. Kirk's Law Corner will be live. Law for Dummies with Kirk Pendergrass and Chris Hallett. I'm sure Ante will be joining him then. Also, Wednesday at 1 o'clock, Punish for Protecting will be live. Wednesday night again, Kirk will be live at 8 p.m. Eastern, 5 p.m. Pacific. Thursday at 1 again, Punish for Protecting. Thursday night, I'll have Tori Harper from that Fox News report on. And I'll have an ad coming out hopefully tomorrow about that. That's going to be incredible, and I think maybe Connie regularly will be joining us. But then on top of that, if you live in New England, I'm trying to get a march together, some kind of event towards the end of December. I already made the event to try and kick some people in the butts to get them going. And we're having a meeting this Sunday at 7 o'clock in Manchester, New Hampshire. If you want to attend that meeting, send me a private message. There'll be about 12 of us there. And then later in the month, we're going to plan an event, a march in Concord, the capital of New Hampshire, if you want to join us. So again, thank you everybody for joining us here at Judiciary Saturday night. Thank you, Kirk, for joining us. I'll see you guys Monday.